Court calls case People versus Dion Lyons.
We're stepping into a courtroom where the stakes are far bigger than just paperwork and procedure. This is People versus Dion Lyons, and on the surface it looks like a routine probable cause conference. But beneath that calm opening, a drug test, a positive result, and a defendant standing in front of Judge Simpson insisting he's sober. Today's hearing starts with a simple question. Was that positive test just leftover traces from before his arrest, or is something else going on? See, his attorney argues timing. The prosecution stays measured, and then the judge does what seasoned judges do best. He starts asking the questions that cut straight through the noise. What makes this case gripping isn't just the lab result. It's the tension between addiction, accountability, and court supervision. When someone claims they're clean but the system says otherwise, who do you believe? And more importantly, what does the court do next? Stay locked in. Because this hearing quickly turns from procedural to deeply personal.
Represent on behalf of the people.
And good afternoon, Your Honor. Attorney Kevin Bassan, P71061, on behalf of Mr. Dion Lyons. Mr. Lyons, his name for the record.
Thank you.
Judge, today is the date and time scheduled for PCC conference, Judge. As of today, I don't have discovery. I did speak with the people. I believe I will be getting that very, very soon to move forward. And there is a community corrections report in the file, Judge.
Yes, there is.
And so, want me to address it now, Judge, or?
Pardon?
You want me to address it now?
Yeah. That's a
So I would note, Judge, that was his very first drug screening for his arrest in this particular matter. If I could have one moment, though.
Yeah.
Okay. And so, Judge, I don't foresee any future dirty drops from my client.
Why do I have these?
So I believe that was in the system prior to his actual arrest and arraignment, Judge. He was arraigned recently. And I believe at the time that he did drop for community corrections, that was still in his system. It's my understanding my client is sober. There is nothing in his system as of today. And so obviously if the court wishes to test him, but I don't foresee any future positive screens from my client.
This is a bold statement. When a defense attorney tells the court he doesn't foresee any future positive screens, he's essentially staking credibility on his client's sobriety. That's not casual language, that's positioning. The argument here hinges on timing. The defense is saying the positive test was simply residual, something still in the defendant's system from before arrest and arraignment. Legally, that distinction matters. If the substance was consumed before bond conditions were imposed, the violation question becomes murky. But here's the tension. Courts deal in evidence, not forecasts. A positive test is a positive test unless proven otherwise. Notice how Judge Simpson immediately zeroes in on dates. Arrest date, arraignment date, test date. He's reconstructing a timeline. Because in drug supervision cases, timing is everything. If the numbers don't align, credibility starts to crack. And at this point in the hearing, the judge is listening carefully, but he's not convinced yet. Do you think the timeline explanation is enough to justify that positive result?
People have a position on this. What was it? What date was he arrested?
Give me 1 second, Judge. It was on the 17th, and I believe.
Yes, I know that. I got that,
I
but
think he was arrested, if I'm correct, I believe it was the 15th, like literally 2 days before that arraignment, if not the day before. But it was a very short amount of time, Judge. But I think it was the 15th, if I'm correct.
no, that kind of would make sense. And then on the 20th, I have a test. If you test today, are you going to test clean?
Yes. Yes, sir.
That "yes, sir" carries weight. When a judge directly asks, if you test today, are you going to test clean? That's not rhetorical. That's a credibility checkpoint. The defendant just gave the court a clear, unambiguous answer. And here's the legal reality. If today's test comes back positive again, that answer becomes evidence of dishonesty, not just relapse. Judges take that personally, not emotionally, professionally, because bond is built on trust. You're out of custody because the court believes you'll follow the rules. A clean test today doesn't just protect his freedom, it validates everything his attorney just argued. But if it's dirty, now we're talking about possible bond revocation, stricter supervision, or even jail. This is the moment where the courtroom gets quiet in a way that matters. Everything now hinges on chemistry and confirmation. Would you gamble your freedom on that answer?
Anything from the people?
I'll leave it in the discussion before.
All right. What I'm going to do is I'm going to order the defendant to go over, grant your adjournment. Probable cause conference will be adjourned to February 19th, 2026, 9 a.m. Bond will continue. The defendant is to go over to community corrections. You can let them know I want him tested today. And here's what I'll do. I'll leave that. If it comes back negative, then counsel, we don't need you back, or you can appear. We don't need you back. I'll just leave everything as is.
Okay.
If it comes back positive, we'll try to leave a number.
I will.
You probably got other places to go. So leave a number with my staff and I'll let you appear via Zoom so we can address it.
No problem. Thank you very much.
You are not to leave until we tell you that you can leave this facility over here. Understood?
Sir. Thank you.
All right.
May I speak to this opposite in the conference room for me?
Pardon?
Can I speak to him opposite in the conference?
Absolutely.
All right. Thank you, Judge.
And then he just needs to go over to community corrections.
No problem. Thank you.
All right. Reset.
And then on behalf of the people.
And good afternoon, yeah. I'm attorney Kevin Bassan, P71026, Mr. Dion Lyons. Mr. Lyons, take your name for the record again.
Dion Lyons.
Okay. We have a problem. He came back. We received, I think, from your office, Mr. Bassan, Trinity Health documentation. Neither, and I think
That's
you were.
correct, Judge. From January 24th.
Yes. And the problem is that the medications listed here would not come back as this on our test. So something else is going on.
And if I could explain briefly, Your Honor.
Certainly.
So on the 24th, Mr. Lyons, along with his mother, went into Trinity Health because Mr. Lyons was having withdrawal syndrome because he had not consumed any controlled substance since his original consumption prior to his arrest. Whatever is in the system right now, Judge, I believe is still trace amounts from him using prior to his arraignment. And the reason why I submitted the Trinity Health form is to show that what they prescribed him were certain medications to help him control his vomiting and to help him control his withdrawals. There was also talks by his doctor to put him on Suboxone to hopefully help that transition. That hasn't been done yet, only because again he's technically under court supervision and still can't test positive for any type of controlled substance. So my argument, Judge, is that he's addressing this. I don't believe what's in the system right now has been controlled substances taken prior to him being placed on bond.
Except this came back Suboxone-like, right? And
I believe so, yes.
yeah. Okay. Counsel, I hear what you're saying. And all right. Sir, I'm just going to tell you need to be honest with me. Okay. Because I get what your attorney's telling me. Okay. Have you been taking Suboxone?
Last time I took something was
The
last time I took something was 2 days before my arrest, or one night before my arrest. Everything that I dropped dirty for, I've been taking the last.
Hold on a second. So here's what I'm asking you. Okay. Because the last part of what your attorney said is the part that really became curious to me. The doctors are considering putting you on Suboxone.
Right.
And you had a heroin addiction or
Opiate.
what?
Opiate.
Oh, some type of, okay.
Yeah.
So an opiate addiction. Okay. Let me just say this way to you, okay? Sounds like you've been struggling trying to get off.
Mhm.
Your mom took you, I think that's your mom back there, took you to Trinity Health, trying to alleviate some of the things.
Right.
All right. And it's a struggle, right? Right?
Right.
Sometimes when people hear that the doctor's going to put them on, but you're under court supervision, they find a way to get their hands on some things to help.
Mm-hmm.
And so what I'm asking is somehow, did you get your hands on some Suboxone somewhere?
Yes.
Yeah.
And there it is, the turning point. Judge Simpson gently probes, not accusatory, not aggressive, but strategic. He frames the struggle. He acknowledges withdrawal. He recognizes addiction as a battle. Then he asks the key question, did you somehow get your hands on Suboxone? And the defendant says yes. That admission changes the energy in the room. Suboxone is often used to treat opioid addiction. But here's the complication. Taking it without authorization while under court supervision can still violate bond conditions. The judge isn't just determining drug use, he's evaluating honesty. Notice how he doesn't immediately threaten jail. Instead, he tests consistency. Was it before arraignment? After? Is this relapse or is this desperation to manage withdrawal? Addiction cases blur lines between misconduct and survival, and Judge Simpson seems to understand that tension. But honesty now becomes the currency. If the timeline doesn't match the lab results, the court has a problem.
Before, though. Before I was arrested. I stopped everything the night I was arrested.
Okay. All right. So what you're telling me is that from the time you were arraigned, you haven't taken Suboxone.
No.
Basically, that's what's showing up here.
Yep, that's the last time I took anything.
All right. So, counsel, just so that I'll say this. I don't know whether to believe you or not regarding when you took it, okay? I'm just going to say this, okay? You're fighting through it.
Right.
Right?
Okay.
And if you did do it, I'm going to be honest with you, I probably am not necessarily going to fault you because I just wouldn't. Okay? In this instance. So, counsel, will they put him on Suboxone if the court? I mean, is the only thing that's preventing him from going on Suboxone is the court orders, or? Pardon?
I told the doctor I didn't even want to take it. I didn't want to take nothing of it.
Well, okay. No, I'm not going to have you explain it. Okay. So you think that if you test more, right,
Mm-hmm.
that this is going to be out of your system?
Correct.
Okay. I'm going to communicate something that community corrections communicated to us. That what you may want to do is you might want to send this test out for confirmation. That kind of lets me know kind of where your levels were. All right. So you might want to pay the $30 to do that. I mean, I know you don't want to, I get you. I hear you.
This is judicial pragmatism in action. Rather than react emotionally to a positive screen, Judge Simpson offers a path forward: confirmation testing. For $30, the defendant can send the sample out for lab verification. Why does that matter? Because initial screens can sometimes produce results that require confirmation for precise levels and substance identification. It's a fairness safeguard. But listen to the subtext. The judge says he doesn't want to be in a position where he has to lock you up. That's balance. Courts must protect the integrity of supervision, but they also recognize recovery is messy. Then comes another strategic move: increasing testing from twice a month to once per week. That's accountability without immediate incarceration. It says, I'm watching closely, but I'm giving you a chance. The system here isn't just punitive, it's corrective. The real question is whether the defendant can stabilize before February 19th.
But I also don't want to, it seems to me, be in a position that I got to lock you up either. Right? So balance it against that.
Right.
Okay. So are you going to do that, you think?
Yeah, I will.
Okay, so go back over there and do that before that sample is no longer there. Send it out for confirmation. Since you're doing that for confirmation, you're represented by counsel. I'm going to leave the 19th. We currently have him on what week? How often are you testing?
Twice a month.
2 times a month?
Yes.
All right, here's what I want. I'm going to change that just in this interim period and then bring you back to it. Okay, you follow me?
Follow.
So what I want is 1 time per week testing. We'll get to the 19th, revisit it, and see where you are. We should also then have the confirmation of the test that you took today.
Okay.
Okay. All right. So I'm going to leave everything as is that we set this morning. I'm going to let you go. Go get that confirmation test scheduled, and then you'll be on weekly testing, and then we'll figure out like where we are on the 19th.
Thank you.
You understand?
Sir.
All right. Thank you. All right.
Thank you very much, Alan.
Thank you, sir.
What we've just witnessed is a courtroom balancing act. Judge Simpson did not revoke bond. He did not order jail. Instead, he tightened supervision, required confirmation testing, and set a clear benchmark for February 19th. The case now pivots on data: confirmation results, weekly tests, and consistency. The broader implication: courts increasingly recognize addiction as a medical struggle, but they still demand transparency and compliance. Dion Lyons remains free, but on thinner ice. If future tests come back clean, this hearing becomes a turning point toward recovery. If not, the consequences escalate quickly. This is what modern supervision looks like: structured opportunity paired with accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.